For pronouncement of judgment, item number 1, criminal jail 25 of 20.
The criminal appeal is dismissed. One minute. Oh, no meaningful here. No, no. Yes,
Yeah. Plus IA for listing for bail, paper book is ready, my lord. Your lord.
next week.
Next month.
My lord, I mentioned item number 8, my lord.
Item number?
8.
Yes.
I am filing affidavit today, my lord. Matter may be adjourned and it may be listed later, my. With affidavit.
Mr. HR Survey.
Yes.
Who is your counterpart?
Counterpart,
Have you informed?
I failed to inform, but I will inform, my lord. Today.
Then you wait for your turn. I will inform with different issue.
Ready list for admission, item number 1.
May I please lordship, madam? Appeal against conviction, madam, 6 POSCO, madam,
POXO.
and 3 life imprisonment.
Appeal to लिखियो.
Evidence is contrary, lordship.
Heard Mr. Ardib, counsel for the appellant, and MS A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam. Post of as per order dated 28/08/2024, the service of notice upon the respondent number 2 has been duly affected. Post of in view of the same, the service of notice upon the respondent number 2 is treated to be complete. Post of as the records from the trial court, received, office to take steps for preparation of the paperwork. Yes,
I is for bail, lordship. Yeah, lordship, I will read the evidence of the PW 1 to.
oh wait, state has not filed objection.
No.
This is the first time we are taking up.
Lordship.
They have a right to file objection.
I love it. Copy also may be served to us.
Copy, we have already served, lordship. Legal aid counsel, I am.
Legal counsel served to us.
করেছে না না আপনি তো অফিসে তো করেছে
On the night, nine copy.
Okay, you get a photocopy from him. Get a photocopy from him.
We will do it. Give us the copy, we'll do it and give it to you.
They will get you Xerox. Heard Mr. Ardib, learned counsel for the applicant appellant. This is an application under section 389(1) CRPC, seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Post of MS Begum, learned additional public prosecutor, appearing for the opposite party number 1, state of Assam. Yes,
4 weeks. Sir.
has sought for and is granted 4 weeks time to file an objection on behalf of the state. Post of
Can I get a fixed date, lordship, on November?
appeal to লিখিব list the case after list the appeal after 4 weeks.
Items 4 and 5.
May I please, Lordship? Lordship, I am for item number 4, Lordship. In this case, paperwork is ready, Lordship. Will we come up for hearing, Lordship?
I will. Can you listen from
Yes,
here?
MS Begum. Records received. Huh? Record received. Paperwork is ready or what? 4, 5, no? 4 or 5 একেলগে আছে। Two appeals.
I am for item number 4.
Item number 4.
Yes.
You are for
I'm
item
item
number
number five.
five. Have you received a copy of the paper book? Out of the same judgment. Then paper book is ready.
I have received the copies.
So you can, I can observe that paper book be served. You can collect. You have received paper book. You have received paper book. You have received. Have you collected? Let us see.
If some other landed friend had collected, then
Paper book has been furnished
fine. Then I'll get from office.
to
Lordship.
PP. Received on 3/5/2023.
Lordship, I'll.
Okay. And what is this I?
I have for suspension of the.
Are you pressing? Huh?
I am not present.
Then we'll close. Item number 4 লিখিব। Heard Mr. S. Alam, learned counsel for the appellant. MS A. Begum, learned counsel for
Yes. And the public prosecutor has also filed, my lord, objection. As well as, my lord, the informant has also filed objection.
offense.
Offense, my lord, 302.
Yes, PP,
We'll file a.
ready.
We'll file a-
Okay.
So may I
Okay.
proceed, my lord? My lord, the applicant, my lord, he has been in jail since
Let us see the sentence, which part?
sentence, your lordship will see page 63.
Page 63. Paper book.
No, my IA, my
Oh, you are taking up the paper book. Oh, when the
IA, my lord.
all the real materials are available,
Yes, ma'am.
we'll go for it. Okay. Life and fine of rupees 10,000
Yes,
for 341. 302 for 341.
341, no punishment was imposed, my lord. It's
Okay, no
basically for-
punishment imposed.
Yes, basically, my lord, wrongful restraint for,
Okay, let us see the FIR.
yes, your lordship will kindly take up my IA, my lord. Or your lordship will take the paper book, my lord.
I would prefer paper book
My lord.
since everything is available here.
Then your lordship will kindly. FIR, your lordship, page 4, my lord.
returning from the market. Someone assaulted him behind Itochera Kalibari.
Incident
Left him
28.
there. When I got the information at around 3 a.m., I went there and saw that he was lying in unconscious state. When I brought him home and nursed him back to health, thereafter I came to know from him that Doya Hamar,
So basically, my lord, here,
along with two of us, she has confined him. Okay, let us see whether this
I am not Doya, my lord, that is the,
two of his associates.
yes. Then your lordship will kindly see the SARS, my lord. Kindly see page 6, my lord. In the FIR, it was stated that Doya and two associates. Now SARS was framed, my lord, against Daini Singh Udayate, my lord. I am not Doya, my lord. Amar. So the identification was on assumption.
No, whether you have been charged or not,
I have been searched as
or where
Daini
is the charge against you?
page 6, my lord, of the paper book. That may I read, my lord.
No, your names are not here. Darnay Singh Udaite.
Yes, my lord. That is the thing, my lord.
Only one person is charged.
Yes, my lord.
Huh?
And the other, my lord, they are not named here. The police subsequently, my lord, could not arrest the real culprits, my lord, who have escorted.
No, that is on merit.
Yes,
First, let us about the procedure.
procedure. Yes,
Please.
I will. Charges frame against only one person, my lord, Daini Singh.
Let us see the judgment. Then
Yes.
we'll understand.
It starts from page 43, my lord.
Now, you are appearing for whom? Darnay Singh
Yes, my lord.
Udaite.
I am appearing from Daini Singh Pudaiti, who has been punished, my lord.
Yes.
Yes.
So he has been,
Basically, on dying declaration.
he has been charged. Darnay Singh Udaite. Where is the charge sheet?
Search it, your lordship will find, my lord. Page 125, my lord. Page 125. The name of the accused are,
Okay. You are referring from your IA,
no, from the paper book, my lord.
paper book.
Yes, page 125. As per the FIR, my lord, Daya and two associates. But in the search sheet,
Charge sheet.
page 125, your lordship will kindly see there are four, my lord. Panging Hamar, Hukming Hulong, Lotsang Mut, and lastly, my lord, the fourth one is the applicant, my lord. So FIR, as per FIR, my lord, two a person and one Daya. But police has filed searches against 4 persons, my lord. And the last one is.
But
the-
you are a common factor. Both in the charge sheet and as well as order framing charge. Others were absconding
Others were absconding.
in
my lord.
the charge sheet. Others
Yes.
were shown absconder
Absconding
in the charge sheet.
in the search sheet.
You are the person who was in custody
I was in the.
at the time of filing the charge sheet. Now, yes, it is there, accused, page 130, Doya. Now, Doya,
Doya.
he is Doya. And the FIR is Doya.
No, I am not Doya, my lord. That is the.
Doya Hamar, and the charge sheet says Dainez Singh Pudaite alias Doya.
There is no evidence, my lord, that a dying declaration was not exhibited, my lord.
No, I am asking about your identity. We are not going into
Yes.
that. First, let us,
My lord.
uh,
Daini Singh is, I am the Daini Singh.
you must have read the brief at your home,
Yes.
but we have not read. So we do not understand.
I will go, my lord.
So, Sarsit, the IO submitted
Yes,
saying that Dinesh Singh Pudaite,
yes.
alias Daya,
Where is?
he
Yes.
is submitted. I am
Submitted,
saying,
but
what is in paper? I am saying, Mr. What is in paper? I am saying.
Elias Diamal, yes,
Please understand
my lord.
what is in paper. I am reading,
Yes.
and in the FIR, it is also says Doya Hamar.
Doya.
Mar. That is what I am
My lord.
trying to understand.
So before sending for trial, my lord, the police must have investigated and have identified the person to the scene of crime who has given the assault. That is the thing, my lord.
Let us go the evidence.
Yes. Now, if your lordship will,
I know.
before that, my lord,
Along with Rajesh Mishra. Who is the disease? What is your name?
Haradhan, the brother of the, my lord, this PW3, my lord. He was, incident happened on 28th of March at night in the road, my lord. And FIR was lost on 1st of was never, my lord. And my brother, if your lordship may read the cross examination in PW3, my 7 line, 1, 2, 3, 4, 5. My brother was not called at the police station to identify the accused person. That is the thing, my lord. Life and liberty.
For both,
Yes,
both the sides.
both the same. And significantly, my lord, if I can add one more, this victim, my lord, he was alive for 2.5 months. No dying declaration was recorded. Only 161 statement was taken after 2.5 months, but that was also not exhibited by the police.
161 is to be exhibited.
No, sorry, my lord. After death, it was treated as dying declaration. But in cross-examination, they have admitted that it was not exhibited. Because after the death of the person, it becomes as dying declaration.
This process is continuous.
So, and if your lordship will read the, my lord, PW8 also, my lord, the IO, my lord, the things are also clear, my lord. Then no identification was taken. Based on the statement of the, in the court, my lord, this witness informant, my lord, that he is Doya Hamar and Daini Singh. So,
Okay, tell me, Mr. Borua, in such situation, if victim sustains such injury,
my lord,
who will conduct and with there are no other eyewitness,
yes,
who, how TIP is to be conducted? Tell me, we'll understand that this man is in hospital,
yes,
sustaining injury,
yes,
maybe not directly to the meeting date, but death-threatening injury.
yes.
Then in such situation, what is the benefit of TIP? Who will identify the assailant? In how this TIP, because you have submitted TIP, how this TIP is to be conducted?
TIP, my lord, not
TIP, who will be the witness in the TIP?
the person, my lord, who have deposed in the court, my lord, that they know Doya,
Mr. What is the TIP then? Under what section it comes?
section 9, my lord,
Then
of the evidence.
who will identify?
The victim, my lord,
Then victim is in hospital
yes,
with a fracture of 4 cervical
yes,
fracture,
yes.
undergoing treatment. Who else will go to for the TIP?
After the victim was discharged, he was at home, my lord. That is the thing.
When he was discharged?
It is there in the, my lord, evidence, my lord, of PW8, my lord.
Let us see.
That's why, my lord, I'm referring to PW8, my lord. If I can read, my lord,
Informed
page
OC
18.
at that time. Babu Kasaja was lost, after which was forwarded, registered, and dismissed, and I
He was
sent
at home, my lord.
recorded his statement. I visited the PU.
For considerable length of
Also
time.
examined the witness's recorded his statement. In the meantime, the injured person was shifted to, I visited, when he said, but I could not record it, as he was not in position to depose. The given requisition to medical examination report after release from the victim was kept in his original where I visited and recorded his statement. I have also collected the medical report. Medical report collected from after received a medical report. Pay to that court to 8 section 1. In the meantime, I understood the so and so. On the basis of the statement of the witness, I have also searched to arrest another 3 accused. They are already aware. The reasoning was forwarded by Virginia Golden Knight to the reported victim expired 15/6. They sent the dead body to some which I have collected along with friends. The investigation is found will establish the reason good idea and so and so. Shown them the absconder is a sunset, it's a signature. The file was registered Single incident of sensor. The essential case of occurrence is not for. You do not see any open or instrument from the salt. You do not see the mission other.
He died on 15th of June. And statement recorded on 4th of June. He was at home, my lord. And whether he was in a sound mind, that was also not there. But
What is exhibit P14?
14, my lord. It's, my lord, page 123, my lord. (123) and 4, my lord. Since the treating doctor was not examined, my lord,
Oh,
nothing is there regarding the, only after that postmortem report was prepared.
this is a record.
Page 123. ML report, my lord.
Did you object when this was admitted in evidence? Page 21.
Page 21.
Ah.
This is there, my lord.
Now, did you object
No,
when this was admitted into evidence?
that instruction I don't know. Perhaps only on identification.
No,
And
when this P14 was admitted into evidence
yes,
through PW9,
PW9.
you did not object, defense did
Yes.
not object. So don't make that submission.
Yes.
Blunt, grievous, stress. So 28 informative profile recovery করে 23 রাখি লাগবে হ্যাঁ 28/3/2015 not মারিলে পিটন দিব বা পেলাই দিলে রিকভারি পকাইকৰ মতে নেক্সট ডে মৰ্নিং কৰিলে নেক্সট ডে মৰ্নিং কৰিলে এফআইআৰ মতে next day morning কৰিলে information 3 AM আমাৰ 30 তাৰিখে কৰিলে তাৰপিছত এইটো ট্ৰিটমেন্ট হ'ল শিলচৰ মেডিকেল কলেজত 31 তাৰিখে কৰিলে PW9 পৰীক্ষা কৰে এইটো কোনো হেৰি আনা নাই অবজেকশন আনা নাই এইটো প্ৰথম ইনজুৰি ৰিপৰ্ট চাৰ্ভিকেল ইনজুৰি কিন্তু মেইনটো হেৰিত আছে পষ্টমৰ্টেমত আছে পেজটো 115
There is also no eyewitness at the scene of the incident, my lord. So only he said Doya, my lord.
Hmm. Yes, complete distance পড়িয়েছে মানে সার্ভিক্যাল C4 to C5 নিয়ে Let us see your trend of cross-examination.
Yes, my lord. PW, my lord.
No, specific line that defense plea that you are not Doya.
PW.
Procuring defense witness is another thing.
Yes, yes.
Procuring defense witness is another thing.
Another.
But where is the defense you have taken by putting suggestions to the prosecution witnesses? Show us.
PW. 2, my lord.
Because PW3, he says, I knew Daya Hamar
Yes.
from before the incident.
First time, my lord, in the dock.
Hmm.
That Supreme Court judgment is there, madam. He has stated for the first time in the dock after.
No, I mean, Supreme Court regarding this, there will be 1,000 judgments.
Yes.
But we have to look into the facts of the case
Yes.
first.
Yes.
So he says you have elicited
Hmm.
in the by cross-examination
Yes.
from PW3 that I knew Doya Hamar from before the incident.
I knew.
Then in the first line, he says in chief, I know accused, namely Doya Hamar, alias Darni Singh Pudaite.
But.
Right? That he said
He said.
in chief.
In chief.
Then you elicited in cross-examination that PW3 knew Doya Hamar from before.
Before that, my lord, second line, I do not know the full name of Doya Hamar.
It is different thing.
So Doya Hamar is.
That
Dani
is
Singh.
different, mister. Identity is confirmed by PW3. You have elicited.
No, my lord. Since 302 is there, my lord, proof beyond reasonable doubt.
We are not on full-scale hearing.
Yes, yes,
We are, please
yes,
understand that this is a case for application for bail, suspension, whether it is you are successful in making a privacy case in your favor or not. That is all.
then I have to show from the judgment that.
Judgment at this stage, no.
No, my lord, from the impugned judgment.
Then let us start hearing the appeal
No,
instead of,
only 2 paragraphs regarding dying declaration.
we only spend 10 minutes, nothing more in IA. We can spend 1 day, 2 day in hearing.
Mala- Basically, your lordship, I have to draw your lordship.
Since
whether
paper
the
book is ready, we'll just go through it. Yes, what is the other one?
Page 68, my lord, page 68, para 27 of the judgment. The statement of the deceased was recorded. If I can, lordship, draw your lordship, page 68. Para 27.
Hmm.
The statement of the deceased was recorded by the IOPWA. In his testimony, deposed that he visited the place of occurrence, drawn a sketch map. He also examined the witness and recorded the statement. Thereafter, the injured was shifted to the medical hospital for treatment. The IO recorded the statement of the deceased on 4/6/2015 month. In his statement, the injured stated that on 28/3/2015 at about 9 p.m., while he was going to the home, Daya with others, it is actually 2 persons, attacked him with the intention to kill him. As a result, the injured became unconscious. He was unconscious. Accused left the place. When the injured regained consciousness, he made hue and cry. Then the nearby people rescued him. Then his brother took him to Haramza Hospital.
Did
Thereafter,
not recover.
he was shifted to Silchar
Treatment.
Medical College. It is pertinent to mention that prosecution did not exhibit the statement of the deceased recorded by PW8 though the statement is available in the record. However, the statement of deceased record is not disputed by referee. The aforesaid statement is relevant under section so and so so. Then your lordship will kindly see page 69, para 27.1, my lord. In the instant case, while the deceased made his statement under section 161 CRPC before PW8, the injured person was alive and the injured person was not.
There was a delay in lodging the FIR as I had to attend my injured brother for his treatment at SMC. So it will explain what one is. The hill problem is into
Admitted
as a indoor patient.
immediately, my lord.
Hmm?
Immediately next day, my lord. Or following day, my lord. That is the thing. And that is what informant also stated immediately. So that he was unconscious, my lord. So within the middle of the night, my lord, whether he stated.
She's from medical college, my doctor Asani. Medical report, sketch map, inquest report, inquest, 110. When he was released from Silchar Medical College,
That, my lord, from IO, we come to know that on 4th of June,
4th of
June 2015, his statement was recorded at home from PW8, my lord. Page 18, my lord. The statement was recorded on 4th of June. And he was alive for after that up to 15 June, my lord. Page 18, my lord. As per IO, he was immediately, my lord,
also
Admitted.
was posted. I received an information that his brother so and so. Whether GD entry 1189 was exhibited.
GD entry No, one GT entry, my lord, in the paper book is page 109, my lord.
That is exhibited as exhibit 10.
Yes, 10, my lord. It's 109. That is the, after his death, I think.
Separate report. Examination. Judgment separate report proclamation. One 23.
So,
Ayo. Why do not, actually, just tell you, please tell you. Okay, please. 23. This time he is
and my lord, page 20 is the cross examination of the IO. He has stated in page 20, my lord, that the identification of accused was not conducted before sending for trial, my lord. Page 20, my lord, kindly see, my lord. It's but then I will. Page-
That I have seen.
Yes,
But when this IO visited Silsoe Medical College,
Yeah.
he could not record his statement because the disease was not in a position to speak.
exactly.
But
Exactly.
what happened thereafter, that is what we are looking into. Because
Thereafter-
somewhere it is said that he was referred to GMC, meaning thereby his condition deteriorated.
Then again, he released, my lord, and he was in home from.
That is what we are not getting.
Yes, I
the
also.
scan.
So person.
Yes.
And he also, my lord, in his 161 statement, my lord, accused has stated that I was in home. I went
Hmm?
for cultivation and I was in home.
Who?
Accused, my lord, Daini Singh.
Huh.
Daini Singh. He stated in police, in state 161, that he was at home. in that day.
Hmm.
He went for cultivation and day after he came and he was at home.
What is the value of that statement?
Just he was asked, my lord, that was he said.
That has no value.
That is not there, my lord. 161. my
So
lord.
don't make a mention of it. What is there in the paper book, please tell that.
So, my lord, the identification.
This is the, but why this testimony of PW1 and PW3
PW
at this stage is not to be accepted under the rule of res zetia.
Res gestam.
Res zetia.
Section 6, my lord.
Yes. PW1 and PW3.
Then in that way, my lord, in that case, it has to be trustworthiness, my lord. Because
That will be, Mr.
Prima
Those will
facie.
be, trustworthiness will be examined in a detailed hearing. But why this PW1? Because he says specifically
Hmm.
that on the following morning, I so and so went to the house of Horodhon, called him for our usual daily works, but found him in injured condition. Horodhon told us that he had been badly assaulted upon the night before by Doya Hamar and two of his associates.
Doya.
You are common.
Doya, my lord. They
That
said
will
Doya.
say identification.
Doya is a whose name, my lord, nickname or what? Because one thing, my lord, your lordship will see if in the incident, scene of the incident, if somebody beat and whisper in the ear that I have beaten you. So there is a thing, my lord, where the person, stranger can also be, my lord, implicated. That is one judgment I have known. That's right. Because nobody has seen the occurrence. So for identification also, they must have link to the incident.
Mr. Borua, this man, after injury, he was taken to home.
But-
This man, the deceased,
Yes,
so far we understand, he was taken home by his elder brother, went to the spot and found my brother Horodhon Asaji in injured condition lying by the side of the ditch.
yes.
Then we brought him back to our house. On being asked,
On
my brother Horodhon Asaji told me that accused Doya Hamar and two of his associates thrown him to the ditch, as a result of which he became unconscious. After he regained his sense, he cried for help. Then we informed the Toksera outpost, filed the FIR in charge to the Toksera. After 2.5 months from the date of injury, my brother died. So according to this witness, that it was disclosed to him, but according to this witness.
yes, yes.
And plus, according to PW1 also, that disease disclosed to him.
No, PW1 cross said my knowledge about the incident, last line, my lord, cross. My knowledge about the incident is based on what I have heard. from
Yes,
Haradhan.
that he is cogent. He has disclosed fairly that whatever I had heard is from the disease.
This is, yes,
He had no personal knowledge.
yes.
That is clear.
So
And plus PW3,
PW2, my lord,
PW3 says that he knew Doya Hamar from before the incident.
but he do not know his full name and his father name and address.
Mr. Borua, I can show 5 names, 5 persons from your locality, and I could ask,
My lord,
because there are names of two persons. One person, different names. He is known by, I do not know
my lord.
the exact name of sons and daughters of my cousin brothers. I know by their pet name. But if the pet name is with the person
Yes.
is
that is-
connected,
That is, connection should be there. my lord.
connection should be there.
And
So
if-
far,
in cross examination,
for the application under 389, we are not picking up holes here and there.
my lord, kindly see cross examination PW3, my lord, page 10. It is stated that my brother was
For
not-
paperwork is ready, we'll hear. We are not here picking up holes. Your settled position of law, 389. We are not picking up holes here. We are for hearing, paperwork is ready, we'll do it. We are taking up whenever case comes. Yes, what is your judgment? Yes.
My lord, I am appearing for.
I have heard you enough, more than half an hour. Yes,
Yeah.
what do you say?
My lord, my respectful submission, your lordship. My lord, that, my lord, this prosecution witness, my lord, PW 1 to 9.
See,
They-
Mr. Singh, suppose at the case stage of detailed hearing, if this appellant is found connected with the assault, even in that case also, it might not turn out to be a case of 302 or 300 or culpable homicide amounting to murder. It may at best turn out to be a case of 326 or 324. Because no grievous, what we call it, instrument? Sharp, nothing was there.
Plant weapon, yes.
Basically blunt force, right?
Correct.
It appears to be a case. If he is found connected with the injury of the deceased, it may not be a culpable homicide amounting to murder or not amounting to murder. Because of the death of the disease after 2.5 months. It could be a 326 or maybe 324 also, or maybe a case of acquittal. May not be a case of culpable homicide for 302 or 304.
My lord, that.
Tentative.
Fine.
Just I'm putting a query. Tell me now.
He is a two-person. The
Uh,
defense will lay out.
If he, no, that is my, if he is found connected with the injury sustained by the deceased, then also it might not be a case of 302 or 304 because of the date of the disease
After 2.5.
after 2.5 months and from the first injury report that it is though grievous, but it is blunt. Right? So on that basis, you have to make submission.
Thing is that submitting Malad friend is a Doya is not.
Is 1 and same person.
Innocent pudding. But defense failed to prove.
Defense
And
did,
he is a two-person is there.
it is not a case, my lord,
Even
before
they
the,
are
before the learned trial court, that these persons, Daya and Daya Singh Putedi, my lord, two different persons. That was not the case before the learned trial. Now, at the appellate stage, they have put this question. And my lord, if your lordship, my lord, pleases to see the cross-examination part of all the
Because
witnesses, my lord.
that is not their defense plea during the trial,
My lord,
that there is a person named Darnay Singh Pudaite
correct.
and I am Doya Hamar. I am not Darnay Singh Pudaite. It is not the defense plea.
That is not case. That is not their case before the learned trial court. This is one. And another aspect, my lord, so far as this 444, my lord, IA is concerned. my lord. Today we are, my lord, your lordship is considering, my lord, the IA, not the appeal, my lord.
Hmm.
Therefore, my lord, so far as IA is concerned, my lord, at this stage, my lord, I have categorically stated, my lord, as to why, my lord, he should not be released on bail at this stage. my lord.
Please tell.
Yes, my lord, your lordship kindly see, my lord. Will your lordship take a break, my lord, because
Oh,
because-
yes.
Yes, my lord. Let us resume after the fight.
Lordship. Lordship, excuse me, my lord, item number 12, my lord, I am coming 5 minutes late, my lord, I am.
No harm has been caused to you. We have put it for hearing. It will know. Yes.
My lord, at page 6 of our objection filed in IA number 444 of 2024. My lord, at page 6, we have stated, my lord, that the respondent number 2 submits that the bail application filed by the accused person pending disposal of this appeal will be rejected on the following grounds. Number one, my lord, if the accused may misuse the liberty by indulging the similar criminal activity, my lord.
That is not for your
Number
concern.
two, my lord, there will be every possibility of flight risk. Flight risk of the accused person, my lord. The accused person, because two other accused persons, in fact, three, my lord, they are absconded. Absconded in the case.
So come
Your
to
lordship,
the merit for consideration of this application. Flight risk is during the trial. Mainly.
Lord, if appeal also, my lord, your lordship will have to consider, my lord, as to whether, because two other accused persons, they are absconded. Your lordship will bear in mind, my lord. And my lord, so far as the merit is concerned, my lord, and my lord, the person, my lord, the accused person, Daya, and this Dancing Pataudi, my lord, is one and same person, my lord, in my humble submission, my lord. As per the prosecution witnesses, my lord, as well as the impugned judgment that has been passed by the learned trial court, my lord, which says, my lord, the prosecution has well established, my lord, that the Dancing Pataudi and, my lord, this Daya Amar is one and same person. And accordingly, my lord, his guilty has been proved, my lord, beyond all reasonable doubt, my lord. And, my lord, he has been convicted accordingly, my lord, under section 302 of IPC, my lord, in accordance with the law. Therefore, my lord, at this stage, my lord, your lordship saying paper book is there, my lord. Your lordship may, my lord, at this stage, my lord, this application for grant of bail, my lord, may kindly be rejected, my lord, and the appeal, my lord, may be heard on merit, my lord, it can be disposed of, my lord, on merit, the appeal. And this IA, my lord, may kindly be rejected because, my lord, since, my lord, the paper book is ready,
Reflexive exchange. Okay, there is some. You have to try to push a PW1, PW3, 160 statement. It might fit to be maybe an original paradigm iteration. What it? Put no for any put it away. If one is any.
My lord,
Yes, sir.
can you see his statement, my lord? The injured, the deceased man.
এক নম্বরটার নাম কি? বাবুল। PW1 আর PW3 সব ব্যবস্থা করি আমি মেডিকেল কলেজ গুৱাহাটী পৰ্যন্ত চিকিৎসা কৰিলে আমাৰ হয়। PW1 ৰ নাম কি? বেনু মাধৱ দাস। বেনু মাধৱ দাস। কি কৈছে নেকি তাৰ ষ্টেটমেণ্ট ৰেকৰ্ড কৰা বুলি? হুম? হুম? কিন্তু এখন ৰেকৰ্ড কেছ ৰেজিষ্টাৰ হৈছে কেতিয়া 1/4 যদি হয় এইবোৰ চব হেৰি মৰাৰ মৰাৰ পিছত যেন লাগিছে ওইখানে আছে বহি আছে যেন লাগিছে আছে বাবুল আছে জি ন আৰু এক নম্বৰটো এছ মিশ্ৰ বেনু মাধৱ আছে 31 আছে এইটো (31/3/2015) itself.
Investigation, my lord. So far, my lord, may I point
We'll
one?
examine whether because PW1 and PW3 was not confronted with their previous statement.
Oh, only one thing, my lord. That is,
I'm expressing
yes,
something,
my lord.
so don't interrupt.
My lord.
I think you should not have interrupted. Whatever I have found in the case, that is what I am saying, that PW1 and PW3,
Yes,
when their statement were recorded under 161 CRBC, both of them have stated that Doyamar
Doya.
and 2 others unknown had assaulted, and they came to know because that was disclosed by the deceased. That is what their statement is. And perhaps because these are available with the defense, but they did not confront on that aspect to PW1 and PW2. There are two concepts about dying declaration under section 32. Apart from written, there is also a concept of oral. So at this stage, we will not
But his,
inclined.
his dying declaration was recorded on 4th of June, madam.
Yes, there is a
Only
defect
then,
on the part
on
of
that
the.
day, he said regarding Doya.
Huh?
4th of June 2015, when he was not in a imminent expectation of death, when he was in.
But what is the underlying idea of section 32?
He was-
Maybe, see, the wordings,
No, what I'm saying,
30
my lord,
IPC,
that
evidence.
if there is, if words are
we
taken
are-
up,
Mr. Borua, we are not in appeals.
my lord,
Please,
then I'll restrict my.
you reserve all these arguments. We are prima facie,
Prima facie.
only prima facie. C32.
Statements written or verbal?
When the statement is made by a person as to the cause of his death or as to any circumstances or a transaction which resulted in his death in cases in which the cause of that person's comes into question. Such statements are relevant whether the person who made was or was not at the time when they were made under expectation of death. He may not be under expectation of death on 31/3/2015, but he identified the assailant at one, Doya. But whether Doya is that
Dynasty.
tough name, Daine Sang Pudaite, and that will find out, and whether those oral dying declaration is to be accepted at face value or admissible in evidence by the strict rule of evidence. We'll examine that, but so far, perhaps these persons were not confronted with their 161 statement because it was not, I'll not say much.
Only link is that immediately he was taken to hospital. That's my
I have
info.
seen.
So
And this, exhibit 14,
that
exhibit 14,
reliability of PW1,
exhibit.
whether the victim has stated so and so, that is also one point.
There is one specific remark in exhibit 14. You may have a good case. Exhibit 14, 123. 123. Three. Sensory lost below bladder bowel traumatic. A medical experience. Traumatic quadriparesis. কি বস্তু বা? এই রুমাল। এই শব্দটো মাৰি চাওকচোন। এই quadriparesis লিখি লওক। MNOPQR PQR QR PQ Quadriperosis. So on 30th, when he was treated
Yes, ma'am.
for injury,
Yes.
he was almost paralytic. All these medical terms, jargon is difficult to understand, but this quadriparesis, something which has almost reduces the ability to move and feel their limbs.
His condition was deteriorated. That's why he was shifted to Guwahati Medical College Hospital.
But that is,
You are in jail or what?
yes, ma'am. I am
Since
jail.
when?
Since the date of judgment and prior to that also, madam. That is the thing, madam.
If the count, it
27.
might not be 302
Yes,
or
yes,
304. It might be also, if you are connected with the assault,
yes.
it might be 326 or 324 also. Explore that option.
That is there, madam.
For the timing, I don't know. Hard. Then the period undergone might be
Yes.
your benefit, to your benefit. But so far, oral lying declaration is concerned, that is there in 161 on the immediately after registration, both of them have said, Horodhan had said to us that Toya and two others. Others were not named. Other two were not names, but Doya is consistent. And Doya is Daine Singh will see at the time of detailed hearing. Heard Mr. B. Borua, learned counsel for the applicant appellant. NMS A. Begum, learned additional public prosecutor for the opposite party number 1, State of Assam, and Mr. B.K. Sen, learned counsel for the respondent opposite party number 2, that's informant. Full stop. The instant application under section 389(1) Code of Criminal Procedure 1973, the code for CIPC is preferred, seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail. Full stop. The applicant as the appellant has preferred the accompanying appeal, criminal appeal, criminal appeal number 474 2023 against a judgment and order against the judgment dated 27/9/2023 and an order on sentence dated 5/10/2023 passed by the learned sessions judge Limahasa Haflong in sessions case number 28 of 2015. Full stop. By the said judgment and order, the applicant appellant have been convicted for the offenses under section 341 IPC and section 302, IPC. So for the offense under section 302 IPC, the applicant appellant has been sentenced to undergo imprisonment for life and to pay a fine of rupees 10,000, in default of payment of fine, to undergo further rigorous imprisonment, for 6 months. Full stop. No sentence has been imposed on the appellant for the offense under section 341 IPC on the premise that the prosecution did not pray for it. Full stop. Para. Mr. Borua, learned counsel for the appellant, has submitted that there was no proper identification to the effect that Doya Hamar, DOYA, Hamar, HMAR, and Dining, DAINEISANG, Daine Sang, Pudaite, are one and the same person. Full stop. The said aspect is of utmost relevance as none of the prosecution witnesses had mentioned about Daine Sesang Pudaite as the assailant, as the alleged assailant. And by reducing evidence, defense evidence, the appellant was successful to establish that Doya Mar is not known as Daine Singh Pudaite. Full stop. In addition, Mr. Borua has contended that the deceased died about 2.5 months after the alleged injury sustained on 28/3/2015 stroke 29/3/2015. And the fact that the disease died in home goes to substantiate the fact that the disease did not die for an act which can be termed either as culpable homicide, or murder. Full stop. He has further submitted that the prosecution case, due to the death of the deceased, was rested on circumstantial evidence, and the learned trial court had erred in law in accepting the dying declaration of the deceased without the same being exhibited. Para. MS Begum, learned additional public prosecutor and appearing for the state, and Mr. Sain, learned counsel for the opposite party number 2, that's informant, have vehemently opposed the instant application, contending that there were immediately after the disease sustained those injuries on his person, comma, he disclosed to his brother as informant and to his colleague, comma, PW3 and his colleague, co-employee, PW1,
W1.
co-employee, comma, PW1, the name of his assailants, three assailants, sorry, the name of the appellant, along with two of his acquaintances as the assailants. Full stop. The learned counsel for the opposite parties have further submitted that there was no delay in lodging the FIR, as in the meantime, the informant, who was the elder brother of the deceased, comma, who was busy in providing medical treatment to the deceased, and such delay has already been explained during his testimony. Post. The learned counsel for the opposite parties have further referred to the initial medical examination report of the deceased, exhibit P14, to submit that when the disease was first examined on when 31/03/2015, the disease was found to have suffered grievous injury caused by blunt forces. And on that day, comma, the disease was found traumatic, was suffering from traumatic quadriparesis. And it was, the fact was further substantiated from the postmortem examination report. EXT P12 poster. It is a contention that as regards the oral dying declaration, comma, the defense was not successful to disprove the same, and as such, conviction based on these evidences was correctly reached by the finding of guilt based on these evidences was correctly reached by the learned trial court. Full stop. We have duly considered the submissions of the parties and have gone through the materials for the purpose of considering the instant application, keeping into consideration the parameters within which an application under section 389(1) CRPC is to be considered. Full stop. Para. The prosecution witnesses, comma, PW1 and PW3, they had deposed to the effect that immediately after the disease was recovered in an injured condition, comma, the deceased, who was in a condition to speak, comma, disclosed the name of the appellant as the assailant. First off. The defense appeared to have not seriously contested the said part of their testimonies. First off. Regarding identification of the deceased, comma, PW 3 stated that he knew Doya Hamar from a date earlier to the date of the incident, though he did not know whether the name of Doya Hamar was also Diana Singh Pudaite. Post stop. Whether the assailant of the deceased was properly identified or not is a matter which requires a detailed consideration on the basis of the entire evidence stroke materials on record, and the same is only possible at the stage of detailed hearing of the accompanying criminal appeal. Full stop. Prima facie, it appears from the evidence stroke materials on record, prima facie, that the disease after or when he was treated at the Silchar Medical College and Hospital on 31/3/2015, was not in a position to speak, as the IO was refused to record his statement at that time. Full stop. The admissibility as regards the oral dying declaration of disease, as contested by the learned counsel for the applicant appellant, would stand for consideration at the stage of detailed hearing. Full stop. Considering the fact that the deceased was assaulted on 28/3/2015 stroke 29/3/2015, and when he was medically examined on 31/3/2015 at the SMCH, he was found to be traumatically quadriparesis with absence of reflexes. And as per the postmortem examination report, EXT E12, he disease sustained transverse fracture at cervical 6 vertebra, and his
My lord,
C5 to C7
my lord, I beg to leave, my lord, with your
vertebra.
lordship's, permission, my lord, I beg to leave, my lord.
Well, I also have a matter, my lord, motion matter.
Vertebra
Oblige.
were found contused. Post. Paranalite, continue. Having considered the aforesaid aspects, we do not find that the applicant has made out a privacy case for suspension of execution of the sentence passed against him. Full stop. in view of the above discussion, comma, and for the regions assigned therein, comma, hence an application is found not merited, and the same is liable to be dismissed at this stage, full stop, it is accordingly dismissed. The observation made so and so shall not be so and so. In the accompanying appeal. Heard Mr. B. Borua, learned counsel for the appellant, A. Begum, learned additional public prosecutor for the respondent number 1, state of Assam, and Mr. B. K. Sen, learned counsel for the respondent number 2, press inform, full stop. The paper book is ready, full stop. The learned counsel for the parties have submitted that they have received a copy of the paper book, full stop. List the appeal for hearing in due course. You forget it, Moholi? Huh? No, it would treat you as 6 of পেলাই দিছে বুলি কৈছে ন এইটো তাক ভিডিঅ' পেলাই দিছে বুলি কৈছে
Number 17.
May I please? In this case, LCR has not been received. Lordship.
Lordship, regarding this item, Lordship, objection was to be filed. Today, we have received the copy for petition copy, so we will file the objection after.
LCR is also not received.
Not
Not
received.
received.
Okay, heard Mr.
A. Burun.
A. Borua, learned counsel for the appellant, and MS. A. Begum, learned additional public prosecutor for the respondent state. Full stop. As per office note. You have not taken steps for service of notice?
No,
আমাদের
Lordship,
respondent?
that is incorrect because only state is the sole respondent and
No, you have made party or not?
no.
Huh?
No.
Last time, B. Bhuya have appeared, Lordship, she will file objection.
Only we have made party on the state, Lordship.
Okay.
And order-
Okay.
no formal notice is required to be issued. Lordship.
It's not true, Lordship.
Today is the second date. Okay. In view of the office note dated 5/9/2024, comma, await for the case records from the trial court. Raise the case after 3 weeks. I
Lordship.
heard Mr. A. Borua, learned counsel for the applicant appellant, and MS. A. Begum, learned additional public prosecutor for the respondents opposite party state. MS. Begum has sought for and is granted 3 weeks time to file an objection to the instant application on behalf of the state. Please the case after 3 weeks.
Obliged.
Item 18.
Maybe, appellant Miller, I have filed IA for bail. And
Sir, you are not taking steps.
no, I have taken it similar. This
Informant is.
informant,
dead.
this is the code, Miller. I have taken it
Huh?
official,
He died,
yes,
Lordship.
Miller.
His informant.
Informant was who? Victim.
No, informant was.
And you take steps on victim.
50 Miller.
I flipped through the page.
Miller.
I straight away it came to paragraph 60 of the judgment.
Long doesn't. Anyway.
Paragraph 60 of the judgment. I flipped to the page. I came straight. Paragraph 60 of the judgment.
Yes, right, Miller. You know.
It,
Then I-
it would require presence of the prosecutors.
Then I'll take steps on Miller, the victim again. Information again.
Victim died or what?
No, Lordship,
Victim
inform
is
the
alive.
Lordship,
Informant died.
inform wife.
Come to paragraph 60 finding. Then I straight away somehow
Finding method, item number 6.
pending roughly. Oh, report. Yes, Mr. Das, you were supposed to obtain service report
We have asked Lordship, but we have not received, they have not stated anything, Lordship.
after 1 week then.
Lordship.
Yeah, Ahmed.
On next week, Lordship. Because the initial order was passed in the month of April, Lordship may kindly see. They were supposed to get the
Okay.
instruction in the month of April.
Yeah, Ahmed, learned counsel for the appellant and Mr. Kekedas, learned additional public prosecutor for the respondent state of Assam. Full stop. Mr. Das, learned additional public prosecutor, has sought for further 1 week time to obtain a report as regards service of notice from the officer in charge, Tamarhat Police Station. A prayer is allowed to establish the case in the next week.
Obliged.
On hearing, item number 14.
For hearing.
Met Lordship, can you adjourn the matter for a day, Lordship? Senior
Why?
counsel
At
Mohan-
10:30, you
Yes.
should have mentioned,
Yes, Lordship.
huh?
I could not reach the court, Lordship. Mohanto sir will appear in this case, informed that some difficulty to the Lordship.
Yes, Mr. Ahmed, you ready? Okay. Mr.
This okay, Lordship.
D. Swakia, learned counsel, has submitting that Mr. T.J. Mohanto, learned senior counsel, has some personal difficulty to argue the matter today, and on that ground has sought for an adjournment. Para as Mr. Kekedas, learned additional public prosecutor, appearing for the state, has submitted that state has no objection to the prayer for adjournment. List the prayer stands allowed, list that after 3 weeks, on a day 2 weeks by the office.
Obliged.
Go on.
Yes. Oh, this is that Competition Act matter. It would take long time. Sitting in division bench, it is difficult to take up and complete hearing. Okay, Mr. P.K. Bora,
Yes.
learned counsel for the petitioner is present. And somebody else? Mr. W. Ahmed, learned counsel for the respondent 4 are present. MS D. Gupta, learned counsel for the respondent number 1 to 3. 2 and 3. Appearing for Mr. T.J. Mohanto, now as senior counsel, has submitted that Mr. Mohanto has some personal difficulty today and has sought for an adjournment to stop as the request is not objected to by Mr. Bora and Mr. Ahmed, learned counsel for the other sides, comma. No, it is difficult. I don't know. At least I know that next week also I will be sitting in division
Yes,
bench.
your Lordship. It won't be possible. After the break, your Lordship.
No. The prayer is allowed, full stop. Therefore, adjournment is allowed. As sought for by the learned counsel for the parties, lays the case immediately after the long vacation in October 2024 on a date to be fixed by the office.
Obliged, your Lordship.
Item one.
Device checking, because we had some oversight in service. That process has been done, but the agreements have to be whether the company. If the device checking. But you know, the company is still existing.
Before the vacation, if it is 3 weeks, I don't think it is likely to be listed. I have only 2 weeks. Then it will go after vacation then.
If possible, shift can leave before vacation also.
I'll not be there. That is why. If it goes beyond 2 weeks, I'll not be there. After vacation. Okay. Nico, Mr. Arhok, petitioner, D Nat, senior government agor tut likha ase. Huh? D Nat. 2. Response number 3 is available. Yes, MS A Sharma. 3. NK Sharma. Representing HK Das. Agor hin repeat kori dibo. Mr. Nat, learned senior government Bukit Assam, has submitted that during the inter-exam comma after consultation with the judicial department, the finance department is finalizing the matter. Is in the process of okay, has sought for further 3 weeks time to place a status report. Posted. Okay. As sought for by the Learning Council Board of Parties, as sought for by Mr. Nat, and as agreed to by the Learning Council for the other sides, lays the case immediately after the long vacation in October on a date to be fixed by the office.
Lordly, can you fix a date, Lordship?
It will come as and when I'll be available.
Oh, bless you.
Item number 3.
Mr. Dotto, what to do? You are enjoying interim order.
Not in fact, Lordship has passed an order not to publish the
Yes,
return.
if you are successful in convincing, then everything will be set aside.
Once I am sitting there, Lordship, that's,
Question is paucity of time,
yes, I understand, my lord.
because division bench requires more.
Sir, criminal appeal is very, very difficult.
That is personal liberty.
Yes, very difficult.
This way or that way.
Minors
This is
to go-
service jurisprudence.
Yes,
Slightly
yes.
at a lower pedestal than the criminal.
And this is the last court, it's a very difficult.
What to do?
Lordship
I am sure about this thing that next week I will be sitting in division bench.
The Lordship,
Right.
as per the information of the Lordship,
And I don't know about the week commencing from 16th. Right?
let us try on 24th.
No, I'm saying that thereafter I'll not be here.
Okay. Oh, okay.
I'll go for long vacation from the principal seat.
Oh.
I'll go for long vacation from the principal seat.
Lordship may take also break.
No, not break. I am saying long vacation from the principal seat,
I understand. Outline is something like a break.
not break.
Except Itanagar,
No, no, not break, not break.
except Itanagar.
I don't think it is break for me. Doubtful, Mr. I think this was, in all probability, the division bench will continue.
Lordship may
Division bench will continue.
continue.
I am sure for that, the next week, I'm sure. But the information I am getting,
After
so
vacation
divi-
also.
Hmm?
After
then it will go for vacation.
25th of October, madam.
We'll put it like this, same order, then I'll accommodate Mr. Dotto thereafter. Your assisting counsel will be there
Yes.
with the understanding that it will be listed before me, and then thereafter, as per convenience, I'll put
Lordship.
the date.
Yes.
I'll accommodate Mr. Dotto.
Okay.
Okay. If I am sitting in the single, then I'll give priority to this
Yes. Yes. Yes.
because an interim order is operating.
And the post is also lying vacant, my lord.
Sure. B. Dotto, Senior Counsel, assisted by Mr. J. Das, Learned Counsel for the petitioner, and Mr. H. K. Das, Learned Standing Counsel, GH. Right. As agreed to by the Learned Counsel for the parties, place the case for admission hearing, admission. Immediately আগরটুনি লিখে দিয়ক, an endeavor will be made for consideration of the writ petition. The interim order passed earlier shall continue till the next date of justice. An endeavor will be made for disposal. Will accommodate if
Yes. Yes.
that
So
is not to your liking.
The matter
Will
will be now, no date has been fixed.
No, immediately after the long vacation in October.
Okay.
Immediately. Thereafter, we will accommodate.
No, no, my lord. Grateful, my.
Interim order continue.
I can quote.
This will, Mr. Counsel, this will try next week. Because I have to rise, there is meeting. And your case will be considered next week. Not unlike others. Since it is a bail matter. ইদিনাখন ডিভিজনে থাকিব না, সোমবাৰে ডিভিজনে থাকিব। Next Friday দি দিয়ক, মই কৈ দিম। I'll try to fix it next Friday. I'll try to rise early to consider your case. Okay?
Right.
And Anand,
Anand,
for the,
petition.
why this IA?
My lord, there was a typographical error for punishable under section 21. It should be in 20. That's the mistake.
Okay, that this will dispose that I can dispose that only typographical mistake.
Only type.
Hmm.
21, it should be 20. Punishable under section 21. I haven't mentioned it, but it should be 20.
I to include you. Heard Mr. N. Anand, Learned Counsel for the applicant. And Mr. A. Jain, Learned K. Jain, Learned Counsel. You are representing Kayal. Mr. Kayal, S.C. Kayal. He is public prosecutor and a special public prosecutor for the opposite party, Narcotics Control Board. Poster. The instant interlocutory application is preferred, seeking correction of a typographical error appearing in the accompanying interlocutory application, comma, IA, accompanying bail application, comma, BA 1564, 2024. Full stop. It is averred that in the accompanying IA so and so, the penal section, which part?
My lord, punishable under section
No, which part? Where?
in the cost title, page number 2, my lord, and as well as
In the cost title of the
Bail application.
Only cost title?
And as well as in the prayer.
Okay. In the cost title and in the prayer portion of the accompanying I number so and so. It has been inadvertently mentioned as prayer portion here sabo. Second part of quote unquote punishable under section 21 within bracket small b within bracket small Roman 2 within bracket capital C stroke 29 stroke 35 stroke 54 stroke 66 stroke 68 of the NDPS Act, comma 1985 has been typed as so and so instead of উপর পোর্শনটা আছে quote unquote section 20 আর বাকিখিনি লিখে দিব full stop. The learned counsel for the opposite parties counsel for the opposite party has submitted that as it appears as the error appears to be inadvertent typographical error, comma he has no objection if the correction is allowed. Full stop. In view of as it transpires that the error is an inadvertent typographical error, comma the instant interlocutory application is allowed. Full stop. Accordingly, comma in the accompanying I number so and so, comma in the cost title and in the prayer portion of the accompanying I so and so, the penal provision is to be read as quote unquote punishable under section 20 by Hindikibo unquote instead of punishable under so and so 21. Same in other one. Same. তাৰপিছত লিখক মেইন BA গেটত in view of the order passed in I number so and so today, office to cause necessary correction in the cost title and in the prayer portion of the instant bill application, and thereafter to list the case on Friday 13/9. নাম কেটে লিখি দিব BA 2. What is allowed?